Hi, my name is David Fraser. I'm an internet technology and privacy lawyer with the law firm McGinnis Cooper in Canada. Today I'm going to be talking about the importance of privilege when it comes to privacy and cybersecurity advice. I'm going to start with my usual disclaimer. This is intended to be a relatively general overview of the law of privilege in Canada. It's intended to be for educational and informational purposes only. This is a complicated area of the law. There are some exceptions, even though some of the rules seem to be pretty absolute. And of course, if you have any specific legal questions, you should seek qualified legal advice. And that advice is going to be privileged. All opinions expressed in this video are mine and mine alone, and should not be attributed to my law firm or to any of its clients. And of course, I'm talking about the law of privilege in Canada, so of course this relates to Canadian law only. So why does this matter? The reason why it matters is that when it comes to privacy and cybersecurity advice, privacy assessments, threat risk assessments, and gap analyses, they usually identify an organization's shortcomings, and really that's the purpose of them in a lot of cases. They identify how your organization does not necessarily fully comply with its obligations. Thorough reports will often identify serious issues or minor issues. There are some issues that might be in gray areas and are somewhat ill-defined. But these reports can easily be used against you, or they can easily change negligence into recklessness. So anything your diligent consultant says can and may be used against you in court. One really vivid example that I can think of is a class action lawsuit that's currently pending in Canada. The organization had a breach that involved personal information of tens of thousands of people. They had previously had a number of smaller breaches and had brought in a privacy consultant to do a gap analysis, to take a look at what their practices were and what they needed to do to remedy those. The consultant's report identified a huge range of problems. If I had to summarize it, the consultant's report essentially said that the organization was a privacy dumpster fire. It identified just a large range of shortcomings, and really honestly said it was not likely that they were going to be able to get themselves into good shape before too long. Not surprisingly, sometime later, they have a significant incident, again, as I said, involving records of tens of thousands of people, and that consultant's report is not privileged. That consultant's report will have to be produced in connection with the lawsuit. And that consultant's report is essentially going to be exhibit number 1 if the matter goes to trial. It constitutes the smoking gun. If they brought in a lawyer to provide them with advice on their legal compliance, their compliance with the laws, that report would be privileged and would not have seen the light of day. So let's talk about what privilege is. Privilege started out as a rule of evidence, but it has evolved significantly in Canada to become a quasi-constitutional right. It's related to a lawyer's obligations of confidentiality, but it goes well beyond that. So at its very core, information or records that is privileged cannot be required to be disclosed to a third party. And simple confidentiality is not privileged. You can put privilege on a document, and that doesn't change its nature. You can put privilege in an email signature, and that doesn't change its nature. Privilege may be a form of confidentiality, but not all confidentiality is privilege that will be protected by the courts. So all relevant, confidential, but not privileged information has to be given over to your adversary in connection with a lawsuit. That information can also be sought and obtained by regulators in connection with, for example, an investigation after an incident. So there are two main types of privilege that I'm going to talk about here that exist in Canada. The first is legal advice privilege, and the second is litigation privilege. Legal advice privilege, which is usually or sometimes called solicitor-client privilege in Canada or attorney-client privilege in the United States, what it says is where a communication or record or work product is created for the purpose of obtaining legal advice from a lawyer, that is going to be privileged, and it does not need to be required or cannot be required to be produced to a third party. Now, legal advice privilege lasts forever unless it's waived. And it's not up to the lawyer to waive that privilege, it's up to the client. It's the client's privilege. Litigation privilege is similar, but not identical. Litigation privilege is intended to create a zone of privacy around the preparation for a lawsuit, so that the tactical, strategic work product, for example, created by lawyers and created by clients in anticipation of litigation does not need to be produced to the other side and can't be produced in connection with that litigation. So what it says is where the communication record work product is created for the purpose of preparing for actually anticipated litigation. So it has to be litigation that's in process or is actually reasonably foreseeable. Now, it's not limited to communications with lawyers. So, for example, anything that the client prepares internally in connection with the litigation or in consultation with consultants would be subject to that litigation privilege. But that privilege only lasts as long as the litigation lasts. So once that litigation is over, that document can be produced. It can be produced to regulators. It can be produced in subsequent litigation. So what's the issue? The issue is largely with privilege and consultants. So communications with consultants, even on legal matters, are not protected by legal advice privilege. So in the example that I gave, reports produced by consultants will need to be produced to the other side in a lawsuit where it's relevant. Legal advice that is given by a lawyer simply does not have to be provided. Most privacy advice, in my experience, is actually legal advice. We have a federal privacy law, we have provincial privacy laws. Most organizations, when they retain a consultant for privacy advice, they're actually looking for advice on complying with that particular law. And that is, of its nature, legal advice. But there is no privilege that attaches to any of those reports or communications if it's with a consultant alone. And there may in fact be no insurance if it is in fact properly characterized as legal advice and not just business consulting services. There's also an element related to privacy in in-house lawyers. So all legal advice provided by an in-house lawyer is going to be protected by solicitor-client privilege or legal advice privilege. But with in-house lawyers, sometimes it's difficult to draw the line between where legal advice ends and business advice begins. Those lines can sometimes be blurry. If it's business advice, then it's not going to be privileged. Now, let's think about what lawyers usually do, for example, in connection with a cybersecurity or a privacy incident. They advise the client on meeting the client's legal obligations for reporting and notification, if those are triggered, and the lawyer will help you understand what the triggers are and whether you meet those thresholds. The lawyer will work to prepare for any lawsuits that could follow. And in this day and age, you have a reasonably large privacy or cybersecurity incident. You really can anticipate litigation and particular kind of class actions. The lawyer will also prepare you to deal with any regulatory investigations. We'll often take the lead on those investigations and be your primary point of contact, but the key is we'll be working with you to devise your strategy and tactics in connection with that investigation. And then, of course, the lawyer will be helping you deal with any remedial steps that you have to take in order to maintain or bring yourself back into compliance with the legal obligations. And so in connection with a privacy or cybersecurity incident, companies would be very well advised to involve outside legal counsel immediately in the event of an incident. You want to have as much information and records collected and analysis protected by privilege right out of the gate. So the engagement really needs to be framed in terms of seeking legal advice regarding the legal risk and legal compliance issues that the incident raises. Now, consultant work product in connection with a privacy or cybersecurity incident can be privileged if it is prepared on behalf of the client in order to provide information to the lawyer so that the lawyer can provide legal advice. Now, it could also be subject to litigation privilege if you reasonably anticipate that litigation will be the result and that the consultant's report is prepared for the express purpose of preparing for that litigation. And one needs to remember there are no magic words. Whether you mark something as privileged doesn't make it privileged. And in fact, overmarking materials as being subject to privilege may in fact undermine your argument subsequently related to particular records that really are more sensitive. So I hope this has been an interesting and informative background and overview of the law of privilege in Canada, and particularly how it applies in connection with cybersecurity and privacy matters. If you have any comments on this video or any suggestions for subsequent videos, please leave them in the comments below. Thank you very much for tuning in.